Good afternoon. This is Elise Gross with the Presser Law Firm, and I have with me Scott Roberts today, and we're going to be speaking about life insurance and trusts. Before we get started, just a few housekeeping details. If you have any questions during the webinar, please email us to info@assetprotectionattorneys.com, and I'll try to answer during the webinar, and if I can't, if there's not enough time, I will send you an email response. So you just please send in your questions. In addition, if you're not already receiving our weekly e-newsletter, please email us and we'll be happy to get you on there. We also do preliminary consultations complimentary, so if you have anything you want to discuss with regard to asset protection or estate planning, or there's something you feel we can help you with, please give us a call or contact us via that email, and we'll be able to set you up with that complimentary consultation. And finally, if you have a group that would like to have one of our seasoned speakers come speak to you, then please let us know, and we'll see if we can work that out as well. So today we're going to be speaking about life insurance and how they integrate with trusts. We're going to be talking about different tax exemptions. We're going to talk about the interaction. We'll talk about the generation skipping transfer tax. And we'll also kind of circle out with, since we do this primarily at the firm, we'll talk about asset protection and how that works with life insurance. Before we get into the life insurance itself, I just want to give a very brief overview on the different types of trusts, because we'll be circling back after Scott talks about life insurance itself and the different exemptions. We'll be circling back with how the trusts can integrate with life insurance and to get the maximum out of those relationships. So what is a revocable trust? Trusts are broken down into two basic categories, revocable and irrevocable. The revocable trust is the trust you probably know most about, and that's the trust that's basically for the purpose of putting their assets in trust to avoid probate and to be able to just manage it and benefit from those assets during their life. And at death, it passes to whomever the beneficiaries are, whether outright or in trust after the grantor of the trust dies. It's a very simple concept. Main reason is to avoid probate. There's other reasons that it'll work as well, including creating flexibility for distributions after your death, and for protecting beneficiaries after your death from their creditors. But the primary reason is to avoid that process when you die, where it has to go through, all your assets have to go through the court in order to be passed down. The irrevocable trust is created either during life by a grantor, where they transfer assets out of their name into the trust, and the general rule is once that's transferred, they give up any benefit to it and any control. There are some exceptions to that rule, but we're not really going to go into that today. The irrevocable trust is used for asset protection, it's used for estate tax planning, and it's very often used with life insurance. The life insurance trust, which is also known as an irrevocable life insurance trust or an ILIT, is just a particular nuance of the irrevocable trust, which we're going to talk a little bit more about after we discuss the different estate tax and gift tax exemptions and what life insurance is truly about. So I'm going to turn it over to Scott now to go into that.
Thank you, Elise. So when we're talking about life insurance and trusts, we necessarily have to broaden the scope of the discussion to talk about estate planning in general, because those are two of the most used tools in estate planning. And when we do that, it's important that we have at least a fundamental understanding of what the exemptions are that are available to us. And the way to think about this is that anytime assets or things of value move from one place to another, the IRS is going to step in and tax that transfer. If it happens during your lifetime, it's called the gift tax. If it happens after you pass away, it's called the estate tax. And they give us three important exemptions, though, three ways we can transfer free of tax. And these are the three here. The first two are pretty commonly known about, and the third not as much, but we'll just spend a couple seconds on each one of them here. The annual exclusion gifts, very simple, just that each individual can use an annual gift of $15,000 per year. So think about it. Married couple, between the two of them, they could combine give away $30,000 to as many people as they want. If the gifts are not cumulative, so if you don't use them in any year, if you don't use them in any year, you lose them. So, but that annual exclusion exemption is actually pretty important for life insurance and trust planning, and we're going to talk about that in a little bit. The second one is the one that you hear about in the news a lot, and that's the lifetime exemption. This is the one that, politically speaking, Republicans want to, well, if they don't want to do away with the tax altogether, they want this exemption to go very high, and Democrats in general want it to be lower. Right now, it's at $11.4 million per person. So what that means is that you can use that exemption either piece by piece during your lifetime, all at once during your lifetime, or not use any of it, and you can use it all when you pass away. And again, that's per person. So a married couple, that's $22.8 million that they can transfer without any transfer taxes. Importantly, the current law is written such that in 2026, that number drops down to $5 million plus inflation since 2010, which most people are estimating is going to be around $6.5 million at that time. So keep that exemption in mind as well, because that's something that can be very important in life insurance and trust planning. And then this third exemption that we're talking about is the one that not as many people know about. And the way to think about this is to think about before this tax was around years ago, very wealthy families would look down at their children and think, you know what, they already have enough money. Why don't I just leave assets directly to my grandchildren? I could skip a layer of taxation and save a lot of money. So, you know, the IRS gets picked on a lot, but the one thing that they're good at is they eventually catch on to all these types of things. And so they said, okay, you know what? You can go ahead and do that. You can go ahead and leave it straight down to the grandkids and skip a generation, but we're going to tax you once for the transfer, and then we're going to tax you a penalty tax called the generation skipping transfer tax. And so really you didn't get away with anything because the amount of that penalty was equal to the tax rate. So you didn't get away with anything. But the one thing we can legitimately make fun of the IRS for is the complexity of the tax code. And so they said, but we're going to give you an exemption. You can do exactly what we just described up to a certain amount. And to make it even more confusing, that amount is the exact same number as the lifetime exemption, the 11.4 million, and it's also scheduled to go down in 2026. So the way to think about this is that if somebody currently wanted to leave assets directly from them all the way down to grandchildren, they could leave an $11.4 million amount, and they would apply both exemptions to that. The first one would get it from them down to their children, and then the next one would get it from them, from the children down to the grandchildren. Now, the reason that it's important that you understand how this exemption works is that technically most people aren't going to skip their kids. They're going to leave things maybe in trust to their children. But to the extent that we use this exemption inside the trust, then those assets, if done properly, can pass from the kids to the grandkids in the future free of estate tax. And that's something that we'll talk about in a couple of slides, how we can even leverage that amount and get more down there. So the next thing we need to do to kind of continue to lay the foundation is talk about the different types of permanent life insurance. And I'll just kind of run through this scenario here. It kind of goes a little chronological. And before I even talk about the permanent types, let's just talk about the simplest, which is term life insurance, which if you think about that, that's simple as you pay your premiums. A lot of times you can get a level premium for a period of years, 10 years, 20 years, 30 years, that type of thing. And as long as you pay your premium, if you were to pass away during that term, you would get the death benefit. There's no cash value buildup. It's the cheapest type of life insurance that you can get. But in many cases, it kind of fits. What happened though is that years ago, people we're thinking, well, that's great, but if I don't die during the term and I still need the life insurance after that, what am I going to do? So I want something that covers my whole life. And that's where the term whole life insurance comes from. They literally came up with a permanent product that covers the whole life. Very original, isn't it?
Correct.
So a whole life insurance policy works a little differently. We're going to pay a premium to the life insurance company. The insurance company is going to take that money and invest it in their general account. And their general account is invested typically in interest rate sensitive investments, so bonds and that type of thing. Then they're gonna take out a cost of insurance each year, and then whatever's left over is going to continue to accumulate inside the policy. The premiums for whole life insurance are generally not flexible. In other words, you have to pay that premium each year. There are ways that you can coordinate to get the cash value later on to pay those premiums. But one thing is that the premiums are quite a bit higher than term policies. And so people, the next sort of iteration of life insurance was people said, we'd like a little more flexibility and we'd like the premiums to be a little bit lower. So the insurance companies responded with what we call traditional universal life insurance, or just universal life insurance. And it works similar to whole life, but it's different in a couple of different ways, or a couple of important ways. You still pay your premium into the insurance company. The insurance company still takes that money and it invests it in their general account in interest rate sensitive investments. The difference, however, is that you have a lot more flexibility in the premiums. So if you started paying in, you can skip premiums if you wanted, as long as there's enough cash value in the policy to pay the pure cost of insurance that year. The other thing is that the premiums on average are lower than whole life policies. So whole life policies are designed with a dual design, really, where people are trying to build up the cash value along with having the death benefit. They're good for retirement savings, those type of things. But if you're really just looking for the best leverage of premium to death benefit, you'll usually get that in subtype of universal life insurance. Oh, let's see. Do not see the most popular universal life, a properly structured, max-funded, indexed universal life. Well, we are going to talk about indexed universal life on the next slide. And of course, the max funding is just a way that you can pay into that to generate cash value early on. So I'll touch on that in just a minute. So we had traditional universal life, and then think about what happened is in the early 90s, the stock market was just kicking. Everybody was a genius investor. And so what happened is people thought, well, wait a minute, I'm paying my premium into this policy. The insurance company is investing in their general account and only, and I'm using air quotes here, only giving me an 8% interest rate. Of course, we would kill to get an 8% interest rate today, but people thought, well, gosh, I can do better. And the insurance companies responded with variable universal life insurance, where the premiums are paid in, the investments, the cash value is invested in sub-accounts, which are similar to mutual funds. And so the return or the credit to the cash value is based on equity markets. So if the stock market goes up, if the investments, if the sub-accounts that are selected by the policy owner, if they go up, they could go up 30%, and that's a great return. The problem, though, is that they could also go negative 30%. So these policies were really popular until around 2000, 2001. Everybody took it in the teeth with the stock market. And so then the pendulum swung the other way. And that's where we go on to the next type. And so that's when guaranteed universal life kind of came on the scene and became much more popular, because people are like, whoa, I don't like this up and down variability. So what can I do to sort of guarantee to make sure that, I only have to pay a certain amount of premium? So they came out with these policies. Again, premiums are paid in, the insurance company is taking that money, investing in their general account. But what they're doing is they're guaranteeing that as long as you pay that premium, no matter what kind of interest rates or market happens out there, the company is guaranteeing that death benefit. Now, the trade-off for that is they're going to kind of reach in and take a lot of that cash value. So these policies do not build up much cash value. And because of that, you lack a lot of flexibility. So these types of policies, if you ask me, and obviously every situation is different, they fit very well with older people. If you're young, though, and you get into something like this, you might want to think about something that has a little bit more flexibility, but certainly something to include in an overall insurance portfolio. And then what happened is markets started doing a little bit better. People thought, gosh, I'll dip my toe in that equity market, but hey, are there any way to avoid these massive losses that we might have had in variable universal life? And that's where, and the question alluded to this, index universal life became popular, and it's still very popular right now as the insurance companies continue to refine these products. And the way this works is that the premiums are paid. I won't get into the mechanics of how they do that because that would require a little bit of discussion about options and so forth. But basically what happens is the cash value of the policy is credited based on the performance of one or more indexes, such as the S&P 500. So if the S&P 500 returns 25%, you're going to get a positive return in there. Now, what's interesting about these, and the reason that they're appealing in certain situations especially, is that they often have caps and floors. And so the way that'll work is that if the S&P 500 returns, say, 25%, they're going to cap you at, say, 12%. And so you only get up to 12%. But the good news is if there's a negative return in the market or in that index, then you're just going to get either zero, most likely. Some of them have like a 1% floor, but there's going to be a floor. So you won't lose on your investments inside the policy. And what's interesting about that, if you think about it over time, if you never lose, you don't have to hit any home runs to come out way ahead in the long run. In other words, it's the insurance financial example of hitting singles and doubles and being way ahead instead of strikeouts and home runs and maybe not making it. So anyway, that's kind of the background of the main types of insurance that you have out there, which is important, I think, that you have an understanding, because when you're talking about estate planning, like I said, life insurance is one of the tools that are available and that gets used a lot. When we are talking about estate planning, though, the reason that we're only showing on here permanent life insurance is that permanent policies are the ones that make the most sense, because we're typically talking about getting policies to cover estate taxes. We don't know exactly when somebody's going to pass away. If we have term policies, those policies may or may not be around. And that's why overwhelmingly attorneys, CPAs, insurance agents, pretty much everybody recommend some type of permanent policy that fits the situation to deal with estate taxes.
Okay, thank you, Scott, for that background. So I think now this is going to make a little bit more sense when I go into how we own the different types of life insurance and the different types of trusts. And Scott, feel free to chime in at any point if you think you want to elaborate on anything. So life insurance can be simply owned by you as the individual who's insured. It can be owned by your spouse or a business partner or a child or somebody else who has an insurable interest on you. That's the simple way to do it. The downside of that is, from a tax perspective, if you own a life insurance policy, even one that you will never benefit from, when you die, that insurance is included in your taxable estate. So Scott told you currently you have an $11.4 million exemption. Let's take an example of you have about $10 million of assets when you combine your real estate, your liquidity, your business, and you have a $5 million life insurance policy. If you own that $5 million life insurance policy, even if it's a term policy, there's no borrowing ability, nothing, it just pays out. If you die during the term, then your taxable estate is $15 million. And that would cost you, what do you think, about 1.5, Scott? My math's pretty bad. So that'll cost not you, but your heirs about $1.5 million, which means at the end of the day, maybe we shouldn't feel so bad for your heirs, but they would end up with, let's say, about 13.5 million instead of full 15 million. If you just flip that and you put that, instead of owning that $5 million insurance policy in your own name, and we put that in the irrevocable life insurance trust that we're going to talk about, you're going to see how your heirs will end up with this full $15 million. It's just a simple calculation. If you own it, and there are other types of ways you could be considered an owner. They call that incidence of ownership in the IRS code. A little too complicated for today's discussion. There are other ways they can consider you an owner. You just have to make sure that you don't fall within those types of situations. But if you have no incidence of ownership, if you're not an individual owner, we can structure it that it goes outside of your estate. So in your estate, it's taxable. Outside of your estate, if done correctly, not taxable. Now, if you own it in your own name, then you can fully control the insurance, and you can make the decisions as to how the policy gets paid out. You can change the beneficiaries. You pay the premium directly. You get control. But obviously the downside is having the insurance taxable in your estate. The other way that you can do it, where even though you're still an owner for tax purposes, which may be fine if your estate is not high enough, it won't make a difference from an estate tax perspective, is to own the insurance in your own name, but have the beneficiary be a trust. Generally, if you have a revocable trust, you can name your revocable trust as the beneficiary of your life insurance policy. What's the advantage there? Well, I don't know about you, but if I have $1 million life insurance policy and my children are teens and young adults, I would not want them to get a nice fat check when I die. I don't see any benefit to that. I don't think it helps them. I think I'd rather have the money stay in trust and last for as long as possible and be there to assist them rather than be put in the bank where I know what they'll do with it. And I don't even need to go into it because many of you are probably parents and know exactly what your children would do with it. So at the very least, if I'm not concerned about the estate tax and I don't mind owning the life insurance, I would want that insurance to be paid into a trust that I can control the terms of because I've designed that trust during my life and I know how those children are going to get the money because there's going to be a trustee who's going to manage the money and distribute it out in accordance with the terms that I've constructed. So again, if you're not concerned about estate tax, I think that's a fair way to go. Mm-hmm. Scott, any comments on that or?
No, yeah.
Agreed? Okay. So then you have the flip side. What happens if you want to do some estate tax planning? And we're kind of in a limbo situation, and I think we will always be in a limbo situation as estate planners because we don't really know what's going to happen. We only know what's in front of us, and what's in front of us is currently there's an exemption of $11.4 million, which is increasing each year based on some calculation until we get to the year 2026 when it is supposed to sunset to 5 million plus inflation, which, what are we saying? That's about 6 million?
6.5.
Right. So it's going to be 6.5 million, which might be a lot of money to some people, but for many of our clients, that's not a lot of money, which means everything over and above that is going to be taxable. And the estate tax rate, it doesn't take very long to get up to the 40% estate tax rate, which is tremendous. So if you want to do some estate tax planning, you have to really kind of look prophetically towards the future as to how things are supposed to turn out, meaning that the exemption is going to go to about half. And we don't know if there's going to be any changes, based on politics. Who knows? They could get rid of the estate tax. They've talked about that. They could, lower the exemption even lower. So again, we don't know what we're working with. We can only work with what we have today, and we try to create the most flexibility. So here's how life insurance is going to work in an irrevocable trust. What we're going to do is we're going to create an irrevocable trust, and the friendly term is the ILIT, the ILIT, and we're going to have that trust own the life insurance. Now, there's two ways for that to happen. The first way is to take an existing policy and transfer it into that new ILIT. And Scott, you want to touch upon why that's not such a great idea?
Yeah.
Although sometimes it's necessary.
Yeah, when you start with an existing policy and when you transfer it into a new ILIT, the whole purpose for doing that is to get it outside the taxable estate. But if you take an existing policy and do that, if anything were to happen during the 3 years after that transfer happens, then the IRS would pull all that death benefit back into the taxable estate. So if you're going to start an ILIT and you're able to start with a new policy, assuming the economics are the same, then you would be better off with a new policy.
Correct. So you'd have to survive 3 years if you made the transfer. And also, isn't there any sort of value to that life insurance if you transfer it?
Right. Well,
so it might be a gift.
Exactly. So the transfer would be a gift, and there would be a value assigned to that. Interestingly, the law is a little unsettled on the value of that gift.
Right.
Most people just use a rule of thumb as the cash value of the policy. But there's also something called the ITR, the Interpolated Terminal Reserve Value, which the IRS has relied upon from time to time. And then sometimes you actually have to request from the insurance company how they're valuing the ITR to do that. So the bottom line is, if you take an existing policy and gift it in there, there is a gift to that, and you would have to use one of those exemptions that we talked about to cover that, or else you would have to pay estate tax, or gift tax rather. And the value needs to be determined.
Right. So obviously the cleanest way to do it is to create that trust and have the trust buy the life insurance. Now, just before I get into that, the only reason that I can think, two reasons that I can think of where you would transfer an existing policy is, number one, if you're no longer insurable, so your health has declined, but you already have this policy, so you can't really get new insurance, or to repurchase insurance, a new policy, is just prohibitively expensive. So whether it's because of your age or your health or whatever it is, so sometimes you just have to look at the cost benefit analysis and, take the gamble of those 3 years and the fact that there, might be some gift that's involved, some value that's assigned to it. But the general rule among the planners is create an irrevocable trust, an irrevocable life insurance trust, and have that trust buy a new policy on your life inside that trust. And if that is done, then that policy, the value of that policy, will never be included in your estate tax. So your gross estate will be that, based on that example I gave earlier, where you have the 10 million of assets and the 5 million of insurance. If the 5 million is purchased directly by the ILIT, your estate will only be worth $10 million and there'll be no estate tax. The additional 5 million will go estate tax free and income tax free, because the receipt of life insurance is not an income tax event. So let me tell you about this life insurance trust. So the way it works is it's just an irrevocable life insurance trust, nothing that's so special in that. You design the terms as to how the money is going to be distributed upon your death, because there's really going to be no money in it until then, because the policy doesn't pay out. And maybe there's some cash value. You can leverage that. Maybe Scott will want to go into that a little bit. But you can essentially, the majority of the money is going to fund after your death. So if you look at it this way, since you were never going to benefit from the money anyway, why pay estate taxes on it? So the life insurance policy is held, and you can own multiple life insurance policies inside the trust. And the trustee is the legal owner of the policy, and the trustee makes all the payments of the premiums, which we're going to go into next on how premiums are paid. And you are going to dictate how the money gets distributed at your death. It could be a mandatory payout, meaning upon your death, it just simply pays out to the beneficiaries. I'm not a big fan. I don't know about you, Scott, but I don't think you're a big fan of that one either.
I'm not.
We like to make sure that that trust lasts as long as possible, that it uses the generation skipping transfer exemptions so that it can go multiple generations. There's a lot of nuances to it that have to be done when you design the trust. And the best kinds of trusts are not going to be ones with mandatory payouts. It's going to be the ones where the trustee has as much discretion as the trustee is allowed to have to make distributions to the beneficiaries, to your descendants, not just your children, but your grandchildren, even more remotely, depending on what state you're in and your rules against how long a trust can last. Yes, Scott has a question.
I do have a question, Elise. How would it work if a married couple had a policy on the husband and a policy on the wife? Could they put both those policies in the same trust?
Excellent question, Scott. And no, they couldn't. That would be a problem because an irrevocable trust, once you transfer it in, it's considered a completed gift. And so therefore, you wouldn't really be able to separate out those policies where you would have been the beneficiaries, because you want to be the beneficiary of your wife's policy through the trust, and she wants to be the beneficiary of yours. However, we can also structure it if you don't need to be beneficiaries of a life insurance policy. A way to get a cheaper policy is to do the second to die policy. So you can set up, and we have clients, Scott and I have clients actually that have done this, where there's one ILIT for the husband's policies, there's one ILIT for the wife's policies, and then they have a second to die ILIT, where they're both the grantors of that trust.
Should we explain what a second to die policy is?
Maybe we should, Scott. Go ahead.
Just really briefly, actually, I'll take a step back and I'll explain. When you're doing estate tax planning, you're really doing four things at the end of the day, because estate tax planning, people can look at it and say that it's very complicated, but at the end of the day, you're really doing four things. The first thing you're doing is avoiding as much tax as you can by using the exclusions that we already talked about. So that's number one. Number two is you want to discount assets as much as you can. Make them look like they're not worth as much as they are. There's legitimate ways of doing that. Limited partnerships is one way to do that. Voting and non-voting stock inside a corporation is another way to do that. So that's the second thing you're doing. Third thing you want to do is to transfer as much of the growth on those assets outside the taxable estate that you can. And this is where a lot of the creativity in estate planning comes along. So you can do that with gifting, you can do that with sales to defective grantor trusts, you can use that using grantor retained annuity trusts, all these acronyms that are out there is where that comes in. So, but really what they're trying to do is transfer the growth of assets outside of the estate. And once you've done each of those first three things as well as you can, or to the level that you feel comfortable, and whatever tax is left, then you just have to deal with it. And that tax is dealt with in one of four ways. It either you're going to have, let's say there's $1 million of tax once you've done each of those things. That $1 million is going to get paid either with cash that the estate has, it'll be a dollar for dollar type of thing. Or number two, people are going to liquidate assets, sell off things. Usually, you don't get fair market value a lot of times because you only have 9 months to pay that tax. So a lot of people know that. Joe Robbie is a famous example of that. The Dolphins in the stadium.
He's a lawyer.
Yeah. The third way you could do it is that the heirs could borrow money, but then that's going to be dollar for dollar plus interest. There are some sections in the tax code that offers help to small businesses. There's a section 6166 payout, but still you're basically borrowing from the government then. There's a section 303 redemption, but then you're basically just pulling money out of the company. So that's essentially cash. So at the end of the day, though, those three things that we talked about, cash, borrow, liquidate, and then the fourth one is where the reason why a lot of smart, wealthy people use life insurance to pay for estate taxes, because a properly structured life insurance policy, you're never going to pay as much into the policy as you get out of it. So by definition, you are discounting the taxes. One thing I'll mention is that the first three that we mentioned, you don't do anything until you pass away. Obviously, with a life insurance policy, you start paying premiums currently. So there is a time value of money component, which is why we run IRR calculations, and the life insurance still very far outperforms, the other options that you have. Now, all that being said, that's why people use life insurance to pay estate taxes. So then the question is, what type of policy that would you have once you've honed in on the type of permanent policy? But then the question is, would you want an individual policy or a second to die policy like Elise was referring to? And overwhelmingly, not in every situation, but in most situations, a second to die policy is going to be cheaper, because what you do on a second to die policy is you're insuring both the husband and the wife, and the policy doesn't pay off until both of them pass away. So the insurance company's risk is reduced. You don't have to worry about the proverbial bus taking out one of them. It would have to be both of them to pass away. And so the premiums are lower, which is why people use those types of policies. And we started all this because if you did have a second to die policy, also called a joint policy, also called a survivorship policy, that type of policy could not be owned in an individual life insurance trust. You would have to create a second one.
Correct. So that second to die is another way of you do a joint ILIT. So you can have an individual ILIT. And when you have the individual ILIT, if you're married, you can have your spouse as the trustee and your spouse can be a beneficiary. And if you have a joint ILIT, then you have to have somebody else as a trustee. It could be a family member. There's a lot of different types of trustees, maybe beyond today's scope, but you can have a family member as a trustee. They have certain limitations on distributions. And we can get, in addition to that family member, we can also bring in and integrate an independent or disinterested trustee if we want the ultimate flexibility under our trust and allow for distributions for any purpose. But if we don't want to be that flexible, we can still have a family trustee and give discretion, but it'll be limited to health, education, maintenance, and support. And that's basically an IRS standard. So you create this trust, you design the terms, you have the life insurance owned by the trust, and the life insurance pays out at your death or at the second death if you do the second to die policy. And then that's where the terms of the trust kick in as to who gets what, when, and under what circumstances, which is really how you break down trusts in the end. So I want to talk a little bit about how we maximize the amount of money that is part of this life insurance plan. And that goes into how the premiums are paid. So follow along with this. If I create a life insurance trust and I have the trustee is now going to have to pay premiums every year. Well, the life insurance trust has an asset that doesn't have any real value yet because I haven't died. So how does the premium get paid? Where does the money come from? Well, the money is generally going to come from the grantor, which is me. So I am not supposed to pay the premium directly to the life insurance company. So what I'm going to do is I'm going to gift the money for the premium to the trustee for the trust. And from there, the trustee is going to pay the premium. Well, if I do that, I've made a gift. And if I've made a gift, then we have to calculate that there might be some exemption used on that from those exemptions Scott talked about. However, if you remember, the first exemption was the annual exclusion, which allows me to give $15,000 per year to as many individuals as I want. Well, the general rule is the IRS doesn't allow you to use that annual exclusion to give gifts to a trust. The reason being that if you give a gift to a trust, the beneficiaries can't immediately benefit from it. So generally, we wouldn't be able to use the annual exclusion. However, there was a case way back, I don't know what year it was, called the Crummy case. And in that case, it was determined by the IRS that they would accept that annual exclusion could be used for gifts to a trust if a certain protocol was followed, in that whether it's the trustee or the grantor, but someone has to notify the beneficiaries of the trust. that a gift has been made to the trust and they are able to take that money. So if I had a premium and my premium was $40,000 for this policy, so I write a check to the trust for $40,000, and there are 3 beneficiaries of this trust. I have essentially, if you follow this protocol, I've split that $40,000 into gifts for those 3 beneficiaries, which will be under $15,000 per person if you do it that way. Or I can do it, it's 15 for the first 2 and 10 for the third one. However you want to split it up, but it's below $15,000 a person. Those people will have to sign a letter, or should sign a letter, saying, I understand a gift was made to me. I'm declining my right to take the gift, and therefore the money lapses into the trust, and now the trustee has money that they can pay the premium with, and I haven't given any taxable gift. Anything you want to add there?
Yeah, the names of those letters, didn't they come up with a very creative name for those letters?
They are crummy, yes. And whenever I teach this in my course, they're always like, what? Yes, this is actually, it was a human being, the crummy family, CRUMMEY. So it can always have a little bit of humor when you talk about taxes, because it's generally not a funny matter. So the way this works is we've now created a vehicle outside of your taxable estate that will pay out, and there will be no estate or income tax from that transaction. We have now also used our annual exclusion to bypass any gift tax that would need to be paid on the premiums that are being paid by the trust. So it's just a really, if you follow the protocol, and you really do need to follow, because if and when an estate gets audited after somebody dies, you're really going to want to produce those letters. So if you haven't done it, make sure you catch up on them and get educated. I know a lot of people who've created these trusts and then they completely forget about it. And then I know the others who are, just religious about it and make sure that they get done every year. I have a bunch of friends who've told me that every year their father puts a piece of paper in front of them and tells them to sign. They don't really know what it is, but they're told that at some point it's going to be very meaningful to them. So just make sure that you're following through on protocols. The other way that you can pay premiums without even bothering to have to use any of your annual exclusion, because remember, once you use the annual amount, the $15,000, you have to wait till next year to do it again, is to use the assets of the trust to pay premiums. So for instance, let's say the trust was an owner of another type of asset, whether it was a business asset or a limited partnership interest, something that's kicking off income. Then if there are assets in the trust that are kicking off income, then the trustee doesn't even have to get the money from the grantor, because they can get the money to pay the premiums directly from the trust.
Yeah.
Do you want to add anything on that, or?
Yeah, just 2 things. The whole crummy letter thing, the issue with being able to use the annual exclusion is that it has to be called what they call a present interest gift. And if you put it in trust, as Elise was explaining, the beneficiaries don't have a present interest in that unless they're giving it. So what the crummy letter basically says is, look, you can take this money, generally for a period of time, and that then makes it a present interest gift, which then allows us to apply the annual exclusion to it. So that's kind of that issue. And then this other issue of the most likely scenario where somebody's trying to use other assets that's in a trust to pay premiums is when the premiums are very large. So you run in sometimes where you don't have enough annual exclusion to pay the entire amount of the premiums. And so there are several solutions to that, one of which is to use some of your lifetime exclusion, gift an asset in there, like Elise was saying, a limited partnership or a company or something like that kicks off income, even an investment portfolio that's kicking off income that can then service the ongoing premiums. So that's the most likely scenario. Now, there are other ways to get around this problem of not having enough annual exclusion, probably beyond the scope of this, but just to mention what they are, there's a split dollar that you can do. There's premium financing, which people use. So there's different ways that you can get around that as well, but this is one of the simplest.
And just to comment on two things. Number one, when you do transfer assets, business or limited partnership or other investment interests into the ILIT, you're also getting the appreciation of those assets outside of your estate.
Yeah.
So it's not just to pay the premiums, you are accomplishing something else. And then also with regard to the crummy, you may be thinking, well, if I'm a beneficiary of a life insurance trust and somebody gives me a letter and tells me you can take this money out because a gift's been made, why don't the people take the money out? Well, because if you take the money out as a beneficiary, you're being short-sighted. If you don't sign that letter and agree to keep the money in, then guess what? Somehow that policy won't be paid, and then at the end of the rainbow, there will be no life insurance. So therefore, you're not going to get anything. So it's much better to sign off on those little $15,000 a year gifts, because at the end of the day, you'll get a much larger payoff under the trust. So Scott, let's talk a little bit about the GST, and then we'll wrap it up with the asset protection, because it looks like we're running a little low on time.
Okay. One thing I'll address just really quickly, that max funded IUL question, which
Right.
I only touched on, just to more fully explain that and explain how it fits into the issue of trust, etc. So we talked about what an IUL is, an index universal life, and max funded basically just means you're funding it as quickly as you can based on the insurance regulations, as far as how fast you can put money into it. And the reason you would do that generally is that you want to build up the cash value inside the policy. And the reason we generally want to build up cash value inside a policy is for retirement income, because we later on, once it's built up a cash value, we can take tax-free loans out of these policies. The reason that I say all that is that if you have a max funded IUL that you've designed for that, you usually do not want to own it in a trust, because you need to have access to those cash values. And if you put it into a trust, you would, you give up
the grantor loses that ability.
Exactly.
Good
so,
and let's thank our contributor here who let us know that the crummy case was essentially in 1960. Well, it was decided in 68. So thank you. Or the case is 1968. It might have been decided in 1969 as I'm looking.
So leveraging your GST exemption, we don't have to spend a whole lot of time on this because this is sort of an advanced planning concept, but it's basically how using life insurance in your estate plan can help you increase the amount of assets that you can leave estate tax-free, basically. And so if you think about it, on the left side of this column that we have here, where it says use 11.4 million in your exemption in your wills, and when we say wills, we could mean revocable trust as well, like Elise was explaining before. And if we look up above, this is sort of some assumptions. So we say the GST amount is 11.4 million. Let's say we've got a premium of $60,000 per year. And based on life expectancy, we think we would pay that over 36 years. So we would pay a total of 2.1 million in order to get $10 million in death benefit, which is not bad. If you did this the traditional way and you did not allocate any GST exemption to those premium payments, in other words, you just paid the premiums the way we've been talking about them, then you would have, when you passed away, you would still have $11.4 million of your exemption left. You hadn't used any of it. However, what we could do is, well, and that's assuming maybe we don't even have life insurance, but let's say we have a policy inside a irrevocable life insurance trust, and somebody has designed it so it has GST provisions in it. And over time, we allocate 2.16 million of our 11.4 million to the premiums. So what that means is each year we pay a $60,000 premium and we file a gift tax return. And on that gift tax return, we say, hey, I want to allocate $60,000 of my GST exemption to this premium. And the reason that we do that is that then turns the entire death benefit inside the policy, inside the trust, GST exempt, meaning it can go, as long as the trust stays in effect, it can go skipping generations of taxes. In the state of Florida, We have a rule against perpetuities of 360 years. So we're talking a significant period of time. Different states have different rules against perpetuity, but quite a few of them have some pretty generous ones. So in that scenario, after we've used 2.1, we have 9.2 million of other exemption left. Plus we turned the entire $10 million death benefit in the trust GST exempt. So now instead of only 11.4 million that's GST exempt, we've leveraged that up to 19.2 million, a 69% increase. So it's a simple thing, but it's just, this is where estate planning, business succession planning, asset protection planning, life insurance planning, they all get integrated, and this is one of the benefits there.
It's interesting. I didn't even know all of that. That's great. Okay, so let me just kind of wrap it up with how life insurance and ILITs are protected. So depending on what state you live in, life insurance and the cash value in life insurance might be an exemption in that state's anti-creditor laws. But where the ILIT comes in is if the grantor transfers, well, remember, we don't like to transfer, but let's say the life insurance is owned inside the life insurance trust. Well, even in a state where life insurance is not protected, the grantor's creditors are unable to get at the life insurance. They're unable to get at, once the assets are transferred, any other assets are transferred into the ILIT, assuming they weren't done when the grantor had a creditor and they're not fraudulent transfers, then those assets are not reachable by the grantor's creditors. And if it's designed correctly, as it should be, if you're going through the trouble of creating one of these, it'll protect the beneficiaries from the beneficiaries' creditors all the way down the line until the trust is eventually completely distributed out. So if you create the trust in the right way and you design the terms, the beneficiaries won't have any mandatory payouts. They'll only have payouts that are at the discretion of the trustees. Then the beneficiaries' creditors would have no way of reaching any of the beneficiaries' money from the life insurance trust until the beneficiary actually received a distribution and it went into their own bank account. Then there's really, not much you can do about it if there's a creditor in the wings. But the well-designed trust isn't going to make the distribution if the beneficiary has a known creditor. You can also integrate with the ILIT, as we talked about, other asset protection vehicles like limited partnership, LLCs, and things of that nature. And we do have a question. Okay, no, not regarding that. We'll answer that question offline. So I want to thank everybody for joining us today, and especially like to thank Scott for bringing his expertise to the table here.
Thank you for having me, Elise.
You're welcome. And we have a webinar every month, and we alternate between asset protection topics and estate planning topics, but we do try to integrate a little bit of both into each webinar and give a little different perspective. And that's really where this firm kind of is a little bit different. When we do estate planning, we look at the full asset protection picture at the same time, and we do asset protection, we always integrate it with the estate planning. So if you're not already receiving that weekly newsletter, and that does notify you of when the webinars are and what the topics are, please let us know. If you're interested in a complimentary preliminary consultation, if you want to receive copies of our managing partner, Mr. Presser's books, or potentially having a speaking engagement or webinar, for your company. So please let us know. And next month's webinar is October 24th, and it is on protecting your investments. Thank you so much for joining us today, and we look forward to having you on our next webinar.